Well, here we go again, people. I have yet another astounding update from my Oakland case. Just had a hearing last week, quote unquote hearing, as a pretrial conference. And a lot of weird things happened there before we got to the department in which it was actually heard. But the good news for all of us is that this was another one of those Bart Betta hearings. This is the fifth one of these hearings we have with no relevant evidence pursuant to the quote unquote competence of the victim or accused to proceed what they call pro se, representing yourself as your own attorney. They get that wrong every damn time. In any event, the result here was the judge, for the fourth time, reversed the decision, declared my friend competent, and dismissed the attorney. And as you know, if you've seen the videos from the last time we had him, my friend and I, his mom, who's the kid that's in jail, went to visit the defense attorney. It was an absolute joke. An astounding amount of ignorance was displayed in the course of 25 minutes. So there's no way, even had he represented this kid, the kid still doesn't have counsel. You know, not anyone capable of putting on the arguments that he wants to put on and has a right to present. And in short, the U.S. Supreme Court has said about that, no counsel equals no jail. That's the Arger-Singer rule. Comes under Arger-Singer v. Hamlin, 407 U.S. 40. So that said, the really interesting part about this hearing was I was there and in the front row just waiting my turn to go up there and testify at this hearing on some of the issues we had, including what I just said about counsel. And the bailiff came and approached me and asked why I was sitting in the front row, which is reserved for official court personnel. And I said, well, I'm here, and I had my hand on an 8.5 by 11 envelope just full of documents I was going to testify to. And what happened was when the judge came back from break, he had been advised of this. And the first thing he said, and it should be on the record, we're getting a copy of the transcript, we don't have it right now, was that he was not going to hear from anyone on the other side of the bar, meaning me. Now, they know already how much trouble that they're in. They know who the hell I am. They call me the YouTube guy in that courtroom. And they don't want to hear from me. Doesn't matter how educated you are, you know, how correct you are about your issues on the Constitution, history, and laws of the United States, they will not hear you. Now, say what you will, but that's anything but the dictionary definition of a judicial court to which we are entitled in the first instance. You don't go through an administrative proceeding or, as here, you know, a martial law court and then get to your judicial court. That's not the way it was set up to work. We have the right from day one. Now, this judge, and believe me, I was about as red hot angry as you can possibly get, just as I was on a couple of occasions in South Carolina. But just like in that case, over the course of the 5 months I was there, they never saw it. And I worked on myself the prior 3 days to be damn sure that I did the right thing when the time came. And just sat there and took it because I knew, well, I didn't anticipate what he was going to do by saying he wasn't going to hear anybody. When he did that, bang, the ball game was over because you've effectively denied the kid counsel and you've denied the admissibility of any of his unopposed constitutional issues. That's an open admission. That's not a judicial court, and every law they're trying to enforce is a bill of attainder. And it may be much worse than that, but that's Article 1, Section 9 or 10, as the case may be. An issue very rarely before the 9/0 farts in the last 150 years, but it's going to be in this case. So, and by the way, when the judge did this, this was the only case there. It was on lunch hour, and there were 4 of us in the gallery, and he knew that all of us were witnesses in this case. He had to know it. And there was no reason for him to make that statement unless he wanted to help us by setting the record, by admitting what I just said. He's not going to hear anybody on the other side of the bar. We're all ignorant, doofuses there that don't know a damn thing about the law, and only their attorneys do. Well, trust me, if I had made a recording of that session we had with the defense attorney on December 10th and given it to you, you'd have no trouble at all figuring out who the hell knows the law and who doesn't. So what I'm doing here, and I'll update you on this as things goes on, I, up until now, hadn't thought it possible to do a petition for removal of a case from what looks like a state criminal prosecution to a federal district court. I mean, hands down, they have a thing called the abstention doctrine. Comes under a couple of cases. One of them is Ex parte Young, 109 U.S. 123, I think, and the other is Younger v. Harris, a much later opinion. I don't have that one off the top of my head, where they refused to intervene in a state criminal prosecution because we have to respect the sovereignty of the states. Bullshit. There are no states. And that's the argument we're making. And if that's the case, and I've got an 82-page brief on admission of new states unopposed, and that's a document, by the way, you can get in my document packets, constitutional defense document packets. Send me an email at unincourt@gmail.com. I'll get you all the information pronto about these documents. 82 pages. And by the way, just a diversion back to when I interviewed with the attorney, and I think I mentioned it in an earlier video, but I brought everything we had to the table here. I sent him all the documents by email, and 8 weeks later, he hadn't had a chance to read them, and all he said was, it was my interpretation of the law. Couldn't care less. What they're really saying is that, yeah, you're probably right about this, but we're too embarrassed to admit we don't know the law, and we can't admit on the record that we're wrong. And that's exactly what this judge did on the record at this latest hearing on January the 2nd. I mean, there's no mistaking it whatsoever. If they're not going to allow me to testify, I mean, what else is there to say? And by the way, the other thing, I didn't tell the bailiff, but I was there pursuant to our unlimited power to contract. And I would not have needed a license to cross the bar, and yes, I did think about that. And I thought about it seriously over the 3 days prior to this, but I decided not to do it for a variety of reasons. But that said, unlimited power to contract, Article 1, Section 10, the 904 should recognize that clearly. And by the way, if you're going to say that we don't have an unlimited power to contract, guess what? What the government is saying to you, to me, your family, and whatever it is, that you're too goddamn incompetent to be able to make any contract whatsoever. You're not trustworthy. If that's true, how at one and the same time do we form the criminal intent to commit the crime? Damn. I mean, that's so simple, a classroom full of fourth graders are going to get this. Even if law school graduates don't. We're either competent or we're not. And that's a philosophical thing. It goes back to my days when I studied with the late Ayn Rand. Unfortunately, I never had the occasion to meet her. I just got started with her studies about a month after she passed away. It's very unfortunate. Had I done that at the height of her powers during the time when I was in the mandatory high education system, that would have been an awakening. But I didn't know about her, and they didn't say one word about her in any class I was in. But that philosophy studies I had before I got involved with the legal stuff I'm doing now is invaluable. It really is. If you understand the philosophy of what's going on and what the framers attempted to do, and you see where the hell we are today, it can't get any clearer. We're back to a national socialist government, and those, by the way, existed long before Uncle Adolf. And that's what we have now. The National Socialists actually won the Second World War. They didn't lose it in terms of the governments we have in place today. That's just the way it is. But this break I have in the Oakland case has motivated me now to do a petition for removal. And we're going to be filing that, I don't know exactly when, but certainly before the end of January. And when that happens, all the action in the quote-unquote state court stops until this petition is decided, whether the court has jurisdiction and whether we have in fact had our rights violated, and we have in spades here, all 6 articles of the Constitution. I mean, that's the record I set. And, we set an unopposed record like that, and now we're going to come back on these bastards when the dust clears, with that unopposed record and a demand not only for financial damages, which are going to be considerable, but a demand that forces them to make changes in the way they do business. That's what I'm really here to do. So yes, just like your money-grubbing attorneys, I'm there for the payoffs, but in my case, I'm not going to go out there, and buy $1 million car and this, that, and the other things. It's going to finance me for the rest of my life so that my work will continue. That's the best purpose I can think of to put that money to use that I'm going to have coming in. So, about which more later. But anyway, this Oakland, the more it goes on, you got to say, what in the world are they thinking? And I'm going to be sending them a really comparatively nice letter and explaining what I've just been telling you and asking them, we're not going to go to trial. And if you're going to try to keep me out of a trial, I demand you produce a written factual foundation and legal basis by which you're going to do that. In other words, if you're not going to let the kid put on a defense, any defenses he wants and has a right to do, why bother to have a trial? Convict him and get it over with. Simple. But the bottom line here is that in a best case scenario for them is the dumbass rarely, if ever, wants to go to trial in anything less than a murder case, and even then. But they don't want it. It just takes up too much of the judicial economy of the court. Can tie up a courtroom for a week or two with the jury trial, or longer if I'm involved. And there's a chance they're going to lose. Bad enough as that is to one of their own attorneys, can you imagine losing to a pesky pro-per litigant, Joe Sixpack off the street? What the hell is that going to do for your next election campaign? Tough on crime? Ain't. So, they know they're not going to trial. So the obvious question here, which I'm not going to ask at this time as far as they're concerned, is you're not going to go to trial. We get you in front of an inflamed jury later if it comes to that. And we ask you on the witness stand, I'll be asking you myself, unfiltered by one of your state bar association attorneys, exactly what you had in mind when you knew you weren't going to go to jail and that the only viable option was dismiss the charges and get the case over with. And yet you let this kid sit in jail for close to 6 months. And at least 5 of those months, if not longer, you knew you weren't going to trial. What was the point in depriving him of liberty, especially in a court that we can prove never had jurisdiction from day one? Can you say punitive and exemplary damages and up the wazoo? So yeah, it's going to be a big settlement, but that we've earned it because all of us have done our job. I have, his mom has, and from jail, he stood up to him and hasn't been intimidated. We've all done our jobs here and set the record, and they haven't done a damn thing. Haven't mentioned any documents, nothing. It's like none of it exists. And we are going to get to the bottom of that. And if this case reaches the 904, which I hope it does in some capacity or another, that's how you change the way they do business. Because now they're going to have no choice on the unopposed record that we'll be presenting, and not just in this case. I've got 4 decades worth of them, documentary, relevant, admissible evidence to show there's what I call a pernicious, pervasive pattern and practice of premeditated criminal violations of our rights every time out, and they know it. So, that said, I will get back to you with an update the next time we do it on this subject. Thank you. Remember to like my videos, tell your friends, subscribe, and we'll see you the next time. Thank you.